Oftentimes, clients come to see me having a concern that a family member or loved one is no longer able to manage their personal affairs. Under those circumstances, my first thought is to say we need to determine if your family member is incapacitated. And if your family member is incapacitated, we may have to have you apply to be that person's guardian. This can be a costly and complicated court process with a lot of emotional baggage attached to it. With advanced planning, we can try to avoid having a guardianship procedure commenced. If there is a least restrictive alternative, the court will look to that as the solution as opposed to appointing a guardian. There are several least restrictive alternatives that can be planned out in advance, and that's really important if you want to avoid having a lengthy and costly guardianship process. Some least restrictive alternatives include the following. First, you can have a joint bank account. With a joint bank account, the joint owner who is not incapacitated has to be willing and able to manage the account for the benefit of the incapacitated person. And the court is going to want to make sure that the joint owner wasn't added onto the account merely to exploit the incapacitated person's assets. Another least restrictive alternative option is a durable power of attorney. A durable power of attorney is a document by which you can delegate certain authorities and powers to another person. The agent basically steps into the shoes of the grantor of the power and can do any of the powers that are listed on the grantor's behalf. When it comes to healthcare decisions, a similar document can be made called a healthcare surrogate, where the surrogate can speak freely with the incapacitated person's doctor and make informed decisions on the incapacitated person's behalf. One additional least restrictive alternative is a revocable living trust. In a revocable living trust, the grantor of the trust is usually the initial trustee. If the grantor is incapacitated, the successor trustee takes over and can manage the trust assets for the benefit of the incapacitated person. It is important that the incapacitated person's assets be owned by the trust, because the trustee can only manage those assets owned in the trust. If the incapacitated person's assets are still owned in his or her individual name, it still may be necessary to have a guardian appointed. I'm Lisa Hauser of Commodore Singer Basin in Braun. If you have any questions regarding any of these issues, please feel free to contact our office.